Well, awesome. We got a great question that was submitted today. And Sandra, I want to say that you're the one that submitted the question. It's an awesome question. We're going to talk about that today. So let's get started. So the question for today's Murray's Law. And if this is your first time, welcome. The one thing I want to tell you that this is not legal advice. I do these things for legal information, it's education, but none of this is legal advice. If you need something that's specific to you and your situation, call us, schedule a consultation, and we'll be glad to help you. All right, so the question is, who owns the copyright when using Fiverr.com? The initial answer to that is whoever creates the work owns the copyright. Whoever creates the work owns the copyright. There are two exceptions to that. Well, actually, there's one exception, which is work for hire, and work for hire has two parts. And we normally talk about one part of the work for hire, which is if you are an employee doing the work in the scope of your employment. Meaning that if you work at McDonald's and your job is graphic designer, if you design a logo, McDonald's owns that logo. However, if you work at McDonald's and your job is, if you're the line cook or the cashier, and you design a logo, McDonald's does not own that logo because you weren't doing it in the scope of your employment. Does that make sense to everybody? So the second part of the work for hire, which I never talk about because it really doesn't apply to my audience, was if you specifically retain somebody to do a certain type of work for you, and in your written agreement you have a work for hire clause, then it will apply for work for hire. But the amount of work, but it's not everything. Like you can't hire someone to do a logo for you and it's work for hire. There's really only limited circumstances. And I'm just going to read those to you. Let's see. Any contribution to a collective work, meaning, and when I think of collective work, I think of like a CD, how you have a CD and it has like multiple songs on there, or maybe you have poems that has multiple, a book that has multiple poems in there. That's a collective work. And in order for it to be collective, all the works have to have the same owner, meaning they have to be owned by the same person, and at least one of the authors had to contribute to every single piece on there. So you know how you have a CD and you have the main artist. That main artist is going to be on every track, and then they might have a guest artist. So that guest artist wouldn't own the copyright to the song. They would have been the original artist can hire them as a work for hire, and in that sense own the copyright. So that's number one. So if it's a contribution to a collective work. The second one is if it's part of a motion picture or other audiovisual work, if it's a translation, if it's a supplementary work. And when we mean by translation, meaning that you wrote the work and then they're translating it, you own the copyright to that. If it's supplementary work, meaning that if it's you wrote a book and somebody's writing forward for you, or adding a chart or a table, something that's added to something that you've already created. If it's instructional text, if it's a test or answer material for a test or an atlas, like all those things I just named, 0% of my clients, like it doesn't apply to most of my clients. So that's why I never talk about it. But people always like to say, well, it's a work for hire. It's a work for hire, as if hiring a graphic designer and calling it work for hire will automatically assign the copyright to them. And that's not the case. It's only a work for hire if they are an employee doing this work in the scope of their employment, or if you hire them to do a specific work for you, and it's in one of those limited categories that we just talked about, and in the written agreement it says work for hire. So unless you're having someone draw you an atlas or make an answer material for you or create a test, it's not a work for hire, meaning that the person that creates that work for you owns the copyright to it. And that's plain and simple. So now Fiverr actually responded to someone asked this question directly to Fiverr. And it says, I'm just going to read this too because it's very conflicting. This is why I want to do this video. It says, can't turn it that way. Unless clearly stated otherwise on the seller's gig page or description, when the work is delivered and subject to payment, the buyer, which is the person that's purchasing the gig, is granted all intellectual property rights
including but not limited to copyrights for the work delivered from the seller, and the seller waives all and any rights therein. The delivered work shall be considered work for hire under U.S. Copyright Act. So we just talked about work for hire. So that's very important that you hear what they're saying. That's considered a work for hire. So 90% of the things that are coming through Fiverr are not work for hire, because we just talked about what work for hire is. And if work for hire does not apply, then the seller expressly agrees to assign the buyer the copyright in the delivered work. So, and that's what you have to do. When you're working with a third party, when you're working with a graphic designer or a third party, your contract needs to include a copyright assignment clause. That copyright assignment clause is going to assign all the rights that were invested in the owner or in the author to you. And it's going to make you the owner of it. And so you're taking all the rights they had and they're transferring it to you. Sounds great, right? There's nothing confusing about that at all, right? Yeah, it would be if that's where it stopped, but that's not where it stops. Then they come on down and they say, all transfer and assignment of intellectual property to the buyer should be subject to full payment for the gig. So basically you have to pay, and then you get the copyright assignment. Some gigs, including custom created work, charge additional payments through extra gigs. And if you're not familiar with Fiverr, that's what they call whenever you hire them to do work for you, it's called a gig. So they say you have to purchase an extra gig for a commercial use license. So commercial use is not the same as a copyright assignment. Commercial use gives you the permission to profit from the work that they created. I mean, you can take that logo or take that artwork and you can put it on a t-shirt and you can sell it and make money. That's commercial use. It says, this means that if you purchase a gig for personal use, you can own all rights required for such use, and you will not need a commercial use license. And here's the conflict on that. If you just told me in the previous paragraph that when I pay my money, I own the rights to it, I don't have to purchase an extra gig for commercial use. If you're assigning all the rights that you have to me, then I own the copyright to it. Can you put the clause in place after the work is done? If they sign it, I've had people have to go back to their graphic designers and say, hey, will you sign this copyright assignment? I know this was our intention. We didn't talk about it. Will you sign this? If they will sign it, then yes, absolutely. And I actually have a template on my website. If it's not on my website, DM me and I'll send you a link to it. I have a template where you can purchase a copyright assignment and you can use it with anybody. But that was the thing about this particular, how they answer that question. So they basically say, you buy the gig, you own it. And then they turn around and say, well, we can give you, you might have to purchase an extra gig for commercial use. That doesn't match, because if I own it, then I own it and I don't have to, and I can do whatever I want with it. So in that case, what I recommend that you do is, if you're going to use Fiverr, I believe the best thing to do is be upfront with the person that you're ordering the gig from and have this conversation with them and speak specifically to copyright. And I do that too. Like, I talk to them about copyrights and they say, well, yeah, you get commercial use. No. Now we know that commercial use or a commercial license is not the same as a copyright. So when they assign that copyright to you, that means that you have the right to make derivatives of that work. That means they can't take your work and use it for somebody else's. Like, this is an original work to you. And when you're talking to these people, you need to qualify them and say, hey, I need to make sure that you are using original work, that you're not infringing on anyone else's copyright when you're making my gig. That you're not using clip art unless I know about it. That this is an original piece of work that I can actually copyright, and that you are willing to transfer your rights in this piece to me. And that might require an extra gig, but I would rather pay that extra gig than to depend on Fiverr's language, because it's really conflicting. What I had about that. So anybody have any questions about that? So that's my answer for Murray's Law as far as who owns the rights when you're using Fiverr. Initially, the person that creates the work owns the work. Fiverr has some language in there that says that if you pay for it, you own it. But then they go back around and they say, well, if you're using it for commercial purposes, you have to purchase a commercial license. And I think I think they added that language because they noticed that a lot of buyers were adding that language. You know, a lot of buyers have gigs for commercial use. Instead of correcting that, they just added that language. But really, what it's doing, based off of what Fiverr says, you own the right to it, and you don't have to purchase the extra gig for the commercial purpose.